and then counterfeit. And then we're going to have brief tips on how to effectively enforce your brands or your trademarks in the OIBA jurisdiction. So briefly, the OAPI is the French acronym for the African Intellectual Property Organization. So basically, it's a regional organization of 17 member states. We have Benin, Burkina Faso, Cameroon. I'm from Cameroon. Central African Republic, Chad, Comoros Islands, which joined in 2013. We have Congo, Brazzaville, Cote d'Ivoire, Equatorial Guinea, Gabon, Guinea-Bissau, Guinea-Conakry, Mali, Mauritania, Niger, Senegal, and Togo. And each member state has a liaison office present in the country, and this is to facilitate either registrations or applications which have to be filed at OAPI. Because we have the headquarters of the organization in Cameroon that deals with the examination of all applications. So the liaison offices do not examine, they simply act as a forwarding service. Maybe if you have a renewal due today, rather than sending it to Yaoundé in Cameroon, which will definitely get there after the deadline, your applications could be filed at the liaison offices and will take that date of filing, and then the liaison office will forward them to OAPI. So it's a very organized system, which was to the advantage of the brand owners. And it's a unity system where in one application covers all 17 as well. So you don't have the option of choosing only one country. When you file an application, it covers all 17. And you don't have any multiplication of costs as well. So it works as a cost-effective system as well for every brand owner. So we'll move on to the statutory provisions, and Article 7 of the revised Bandia Agreement states that the owner of the mark has the exclusive right to use the mark or a sign resembling it in connection to the goods or services for which it was registered. So that is the article that gives the brand owner the exclusive right to exploit their mark in the OIBA jurisdiction. And then we have Article 7.2 of the same Annex 3 that gives the brand owner the exclusive right to prevent all third parties from making use in business without their consent of identical or similar signs for goods or services that are themselves similar to those for which the trademark was registered. So Article 7.2 is actually the provision that gives the brand owner the right to enforce their trademark against any other infringing party or any other infringing company in the OIBA jurisdiction. So we'll move on to the methods of enforcement and protection of trademarks, and we'll deal with the pre-litigation. Before filing the trademark at OAPI, I would normally advise brand owners to perform an availability search, because the availability search will inform you of any similar trademarks or identical that have been filed in OAPI. And this search application is not only important for those who want to file, it's also important for those who have already filed. And if they're trying to find out if there's another similar trademark that has been filed by a party which is unknown to them, then this application is what should be filed. That way, the brand owner is able to determine if there's a third party which is infringing on their trademark in the OAPI jurisdiction. So it works both ways. It works for those who still intend to file, and it works for those who have already filed and want to, verify if there's any infringing mark that has been filed after the year. So you can also use a watch service to monitor the trademark applications by third parties. That's in line with the availability search application, except that this one is an independent watch service which you could use to inform you if any similar trademark has been filed. Pre-litigation, before going to court, once you discover that someone has registered a mark that is similar to yours in the same or classes, then you could always do a cease and desist letter, or you could go for negotiations towards voluntary cancellation. Because the truth is that some people feel threatened when you come to them with a cease and desist letter and say, hey, I have this registered before you, and I trademark, some of them comply, and sometimes it's more difficult. Sometimes you have to go by way of negotiation rather than having to incur the cost of bringing a opposition action. So you also have those options before choosing to go for litigation. Now, if you have your, if you do your cease and desist letter, or you go for negotiations and they do not work, then in order for you to properly enforce your brand, you have to now move on to the litigation sector. And there are many options that are available to brand owners for the enforcement of their trademarks. And the options that are available will depend on the facts at hand, because there are certain criteria that have to be met or that have to be satisfied that will determine which of the options that you're going to use. So we'll move on to the opposition actions. These are actions that are brought and filed before ORPE. They are examined by ORPE and the decisions are issued by ORPE. And these actions are brought by any interested party within 6 months of publication of the infringing trademark. And that is why I mentioned one of the pre-litigation means of protecting your trademark is to have a watch service or performing searches at ORPE. Because there's no way that if you're an international client, you're going to know if your trademark has been filed by another person in the ORPE jurisdiction. And if the 6-month deadline elapses, then you're not going to be in position to use this option to enforce your trademarks. So you have 6 months from the publication date to bring this action before ORPE. And this option is available for trademark owners where the mark in question, that's the infringing trademark, doesn't conform to Article 2 or Article 3 of the revised binding agreement. Now, the Article 2 of the revised binding agreement deals with signs that are recognized as marks. We have any visible sign that is used or intended to be used and that is capable of identifying the goods of one party for the owner. It goes ahead to state particular surnames of themselves, default, special, arbitrary, fanciful designations. But when you go through, you realize that we don't have, we have not yet moved to the olfactory trademarks because we have only ones that are visible. So contrary to other areas or other jurisdictions where olfactory trademarks are being contemplated, we don't yet have that entrenched in our regulations. Now, Article 3 will deal with the marks that are not eligible for registration, and that is marks that are devoid of distinctiveness due to the fact that they consist of signs or matters that constitute the necessary or genetic designation of the product in question. And we have the second, which is it's identical to a mark belonging to another that has already been registered, which relates to the same or similar goods or services, or where it is resembling the mark to cause confusion. Contrary to public policy, morality, or the law, is likely to mislead the public or business circles with regard to their geographical origin, nature, or characteristics. And lastly, marks that reproduce, imitate, or incorporate armorial bearings. If you have to register a trademark that will incorporate flags, other emblems, or acronyms, or hallmarks, or any international organization, then you're going to have to furnish the organization a document which authorizes you to use that emblem or mark. That document has to come from said organization. So most oppositions which are brought by third parties, they are actually based on the second and the first one. It is identical to a mark belonging to another. So that is the basis for which most parties bring opposition actions before ORPE. Now, when you bring an action before ORPE, they are the ones who forward it to the adverse party, and then you have a 3-month deadline to reply. If you're not able to reply within that 3-month deadline, then you can apply for an extension of time, and then ORPE will now schedule a hearing date, and you have the session, and then the decision is issued. Now, if you do not reply within deadline, there is the clause that says that if you don't reply within deadline, it will be considered that you have voluntarily withdrawn the trademark. But then again, we have Article 18.5, which says that OAPA shall only cancel the decision insofar as the aforesaid opposition is valid. So, if you have an interest in your trademark and there's an opposition brought against you, we will normally advise that whichever agent is representing you responds to the opposition. Otherwise, it will be deemed to have been withdrawn. But then we have the second Article 18.5, which says that they will only cancel the mark insofar as it's valid. So if on all grounds, if you review the opposition statement, and on all grounds you see that look, there is no difference, so there's no similarity, or the goods are different, then, I mean, the brand owner has the right to say, okay, I'm not going to defend this, because OAPA is still going to examine the opposition. The fact that you don't reply does not mean an automatic cancellation, because OAPA is still going to review everything. So once a decision is issued, you have a 3-month appeal, a 3-month deadline to appeal the decision from OAPA. So that is that's the summary of the method of opposition. Now we have claim of ownership actions. They are brought before OAPA as well, and it usually applies where the party bringing the claim has not yet registered their trademark in the OAPA, but has prior registrations in other jurisdictions and is well known. So if you have not yet registered your mark in OAPA and you do realize that, say for example, it has been registered here, you have the option, and everyone has the option of bringing that kind of action. And it's normally advised that whoever is bringing a claim of ownership action has to file the application to register that trademark in the region. So this method actually is a very advantageous for the brand owners who haven't yet entered OAPA will have realized that there is already a trademark existing in the region which is owned by them. The procedure for that is same as for that for the opposition, and then the decisions can be appealed as well. Now, invalidity actions are brought before the civil courts, and they are based on the same grounds as that for the opposition actions. So, the procedure is that which pertains before the civil court. You bring your action, and then normal procedure follows. So for this action, we normally advise that the brand owners are somewhat patient, because the court system is lengthier than the opposition that's brought before OAPA. Now, the cancellation action is based on non-use, where the brand owner hasn't exploited that trademark for an uninterrupted 5-year period in OAPA. Then the cancellation action is brought. Now, it's important to note that OAPA is considered one territory, so the use requirement is satisfied if you exploit it in at least one member state. You're not required to exploit your brand in all OAPA territories. So if you are able to exploit your brand in at least one country, say Cameroon, you will satisfy the use requirement. Then the burden of proof regarding use normally rests with the owner, and once again, brand owners need to be aware of the fact that it's brought before the court, so it will take the normal time frame as a court action. Now, restoration is an ex parte action, and when I put this one through, because we're talking about the protection and enforcement of your marks. Now, you can enforce your mark, or you can take this step to protect your mark as if, for example, you did not file your priority documents in time, or you did not renew your trademark within its deadline. Then you have this option in order to restore your trademark within the OAPA jurisdiction. And it has to be filed within a period of 6 months from the date on which the said circumstances cease to exist, with a maximum period of 2 years. So this is the option which is going to help brand owners who fail to renew their trademark within time, or who fail to effectively claim their priority upon time of filing. So I'm just going to give you a few tips for effective enforcement. As I said earlier, it's very important to have a watch service to monitor the trademarks that have been registered. Secondly, deadlines should be taken into account and monitored so you don't fall foul of any relevant deadlines. Also, there are instances at OIPA where opposition action is brought against the wrong party because trademarks are usually transferred. So it's very important to ensure that the action is brought in the name of the right owner. And also, it's important that the brand owner appoints a competent OIPA IP agent to represent them. Otherwise, the risk, maybe if the person is competent or not, but if the person doesn't do their job well, then their trademark is at risk. So now for counterfeit, we can always do a cease and desist as well. That's a pre-litigation action, and that's usually the first step that's taken when you discover a counterfeit product. You approach the other party to ask them that, look, you have to stop infringing my brand. Now, if they do not stop, then you have the counterfeit seizures. Now, this is a whole procedure that is done before the courts. It's not OIPA that is in charge of counterfeit seizures because these are territorial actions. So what happens is that an application is done at the court, and the courts grant the party the exclusive right to engage in the seizure procedure. Now, it's very important to note that international or foreign brand owners have to provide a sort of security before they seize the action, and this security normally amounts to about 6% of the value of the infringing goods. And there is also the obligation to take a civil or criminal action within a period of 10 working days from the day of which you file or the day of which you effect the seizure. Now, if this is not done, then the other party can bring action against you and claim damages as well. So sanctions for counterfeit include confiscation, destruction, and damages as well. So for an effective seizure, there must be security, and the brand owner has to be doubly sure before effecting the seizure, or there is a counter-action by adverse party. So you need to be sure that you want to take your action right to the end. Because if you effect the seizure and you don't bring the civil or criminal action, then the other party can now drive you to court and you will now be on the defending side. And these sort of actions have to be done very rapidly. And the best bet is always to seize the products at the port of entry. Because the way, I will talk with as Cameroon, the way our markets are structured, you might not be able to easily confiscate all the goods while they are already being disseminated onto the territory. So the best bet is always to seize them at the port of entry, because if I'm an infringer and I'm exporting into the country and I have three distributors, I can give to ABC and C might give to his own people. Now, it's very difficult for the brand owner to track everyone who has those infringing goods. So it's always advised that the brand owners who are considering infringement seizures act as fast as possible. So from the presentation, I hope that we've all understood that the OAPI jurisdiction is one that affords a lot of protection for brand owners. And what the brand owners need is a way to enforce and protect the trademarks. That's what gives the brand owners reassurance about the system. So I hope that the presentation was great, that it was educational, and that you learned a lot about our system. So